Background of Alternative Dispute Resolution, ADR, and what are the advantages of ADR? Explain. Historical background of Alternative Dispute Resolution, ADR. The roots of ADR can be traced back to ancient civilizations, where informal dispute resolution mechanisms were prevalent. However, as societies became more complex and legal systems developed, formal court-based adjudication became the primary method for resolving disputes. Ancient civilizations, early forms of ADR can be seen in tribal societies, where elders or community leaders often mediated disputes. These methods emphasized reconciliation and maintaining social harmony. Commercial arbitration. In ancient Greece and Rome, commercial disputes were often resolved through arbitration, where neutral third parties made binding decisions. Medieval Europe. During this period, the Church played a significant role in dispute resolution, with clerics acting as mediators. Industrial Revolution. The rise of industrialization led to increased commercial disputes. Arbitration became more formalized as a means to resolve these conflicts efficiently. 20th century. The 20th century witnessed a resurgence of interest in ADR, driven by factors such as increasing court backlogs, rising litigation costs, and a desire for more efficient dispute resolution. This period saw the development of modern ADR processes like mediation and conciliation. Advantages of Alternative Dispute Resolution, ADR. ADR offers several advantages over traditional litigation. Cost-effective. Reduced legal fees. ADR processes typically involve lower legal costs compared to litigation, as they are less formal and time-consuming. Preservation of resources. By avoiding the expenses associated with court proceedings, parties can allocate resources more effectively. Time-efficient. Faster resolution. ADR processes are generally quicker than litigation, as they bypass the formal court procedures and delays. Improved cash flow. Prompt resolution can help businesses maintain cash flow and avoid financial strain. Flexibility and control. Party autonomy. Parties have more control over the process and outcome in ADR, allowing them to tailor the process to their specific needs. Confidentiality. ADR proceedings are typically confidential, protecting sensitive information from public disclosure. Preservation of relationships. ADR can help maintain or improve relationships between parties, which is often beneficial in business and personal disputes. Higher satisfaction rates. Collaborative approach. ADR emphasizes cooperation and finding mutually agreeable solutions, which can lead to higher levels of satisfaction among the parties. Customizable outcomes. Parties can develop creative and tailored solutions that address their specific concerns. Reduced burden on the legal system. Decreased court caseloads. By providing an alternative to litigation, ADR helps reduce the burden on the court system. Promotion of access to justice. ADR can make dispute resolution more accessible to individuals who cannot afford litigation. Focus on interests rather than rights. Holistic approach. ADR focuses on understanding the underlying interests of the parties, which can lead to more durable and satisfying resolutions. While ADR offers numerous advantages, it is essential to consider the nature of the dispute and the specific needs of the parties before selecting an ADR process. Some disputes may be more suitable for litigation, while others can be effectively resolved through ADR. Question 2. What is the important alternative means of dispute redressal? What is the position of India regarding the alternative means of dispute resolution? Important alternative means of dispute redressal. Alternative dispute resolution, ADR, encompasses a variety of methods to resolve disputes outside of traditional litigation. Here are some of the most important ADR mechanisms. Mediation. A neutral third-party, mediator, facilitates communication between disputing parties to reach a mutually agreeable solution. The mediator does not impose a decision but helps parties find common ground. Arbitration. A neutral third-party, arbitrator, acts as a private judge, hearing the case and rendering a binding decision. Arbitration is more formal than mediation but less formal than litigation. Negotiation. A direct communication process between disputing parties to reach a settlement without involving a third party. Conciliation. Similar to mediation, but the conciliator may offer suggestions or opinions to help parties reach an agreement. Lok Adalats. People's courts in India that provide a platform for amicable resolution of disputes through conciliation and settlement. Ombuds. An independent person or office that investigates complaints and mediates disputes between individuals and organizations. India's position on alternative dispute resolution. India has strongly emphasized the importance of ADR as a means to reduce the burden on the judiciary and provide efficient dispute resolution. The government has taken several initiatives to promote ADR. Legal framework. India has enacted the Arbitration and Conciliation Act, 1996, which provides a comprehensive legal framework for arbitration and conciliation. Institutional support. Various institutions, such as the International Center for Alternative Dispute Resolution, ICADR, have been established to promote and facilitate ADR. Policy push. The government has consistently encouraged parties to opt for ADR and has made it mandatory in certain cases. Lok Adalats. These have been institutionalized and are held regularly to promote settlement of disputes at the grassroots level. Judicial support. The judiciary has also played a crucial role in promoting ADR by encouraging parties to explore ADR options before resorting to litigation. India's focus on ADR is driven by the recognition that it offers several advantages, including reduced caseload for courts, faster resolution of disputes, lower costs for parties, increased party satisfaction, preservation of relationships. By promoting ADR, India aims to create a more efficient and accessible justice system for its citizens. Question 3. Justice delayed is justice denied. Critically examine this statement. Justice delayed is justice denied, a critical examination. The adage justice delayed is justice denied is a powerful statement that encapsulates the core principle of a swift and efficient judicial system. It underscores the notion that the timely resolution of disputes is essential for maintaining public faith in the legal process and upholding the rule of law. The corrosive effects of delay. Erosion of trust. Prolonged legal proceedings can erode public confidence in the judiciary. When people perceive the justice system as slow and inefficient, it undermines its legitimacy. Economic hardship. Delays in civil cases can lead to significant financial burdens for litigants, particularly for individuals and small businesses. Emotional distress. For victims of crimes, the delay in the legal process can exacerbate their trauma and impede their healing process. Witness deterioration. The passage of time can affect the memory of witnesses, making it more difficult to establish the truth. Perpetrator advantage. In criminal cases, delays can benefit the accused, allowing them to evade justice or intimidate witnesses. Nuances and exceptions. While the principle of timely justice is paramount, it is essential to recognize that there are instances where delays may be justified. Complex cases often require thorough investigation and deliberation, and rushing to judgment can lead to wrongful convictions or unjust outcomes. Moreover, the right to a fair trial, which includes adequate time for preparation, is a fundamental principle that must be balanced against the need for expediency. Mitigating delays. To address the issue of delayed justice, various measures can be implemented. Case management. Effective case management can help streamline legal proceedings and reduce unnecessary delays. Alternative dispute resolution. ADR encouraging parties to resolve disputes through mediation or arbitration can alleviate the burden on the courts. Technology. The use of technology can improve efficiency and access to justice, such as electronic filing and case management systems. Judicial reforms. Implementing reforms to increase the number of judges and improve court infrastructure can help reduce case backlogs. Conclusion. The maxim "justice delayed is justice denied" remains a potent critique of legal systems that fail to deliver timely justice. While acknowledging the complexities involved, it is imperative to strive for a judicial system that is efficient, accessible, and capable of delivering swift and fair outcomes. By implementing appropriate measures and fostering a culture of accountability, it is possible to mitigate the negative consequences of delayed justice and uphold the principles of a just society. Question 4. Give a short introduction of the Arbitration and Conciliation Act, 1996 and discuss main causes of its enactment. Arbitration and Conciliation Act, 1996. The Arbitration and Conciliation Act, 1996 is a comprehensive legislation in India that consolidates and amends the law related to domestic and international commercial arbitration, as well as the enforcement of foreign arbitral awards. It also defines the law concerning conciliation. Main causes for enactment. The primary reasons for the enactment of this act were overburdened judiciary. The Indian judiciary was grappling with a massive backlog of cases, leading to inordinate delays in justice delivery. ADR mechanisms, particularly arbitration, were seen as a viable alternative to reduce the burden on the courts. Need for international commercial arbitration. India was emerging as a global trade player and there was a growing need for a modern legal framework to facilitate international commercial arbitration. The Act aligned Indian law with international standards, making it attractive for foreign investors. Ineffectiveness of previous laws. The existing arbitration laws were fragmented and outdated. A consolidated and modernized law was required to provide a clear and effective legal regime for arbitration and conciliation. Promotion of alternative dispute resolution. The Act emphasized the importance of ADR as a preferred method of dispute resolution, promoting efficiency, party autonomy, and confidentiality. By addressing these issues, the Arbitration and Conciliation Act aimed to create a conducive environment for arbitration and conciliation, thereby enhancing the efficiency of dispute resolution in India. Question 5. Explain the salient features of Arbitration and Conciliation Act, 1996. What are the advantages of arbitration? Salient features of Arbitration and Conciliation Act, 1996. The Arbitration and Conciliation Act, 1996, is a landmark legislation in India that governs the process of arbitration and conciliation. Some of its key features include consolidation of laws. The Act brings together various laws related to arbitration and conciliation under one umbrella, providing a comprehensive legal framework. Emphasis on party autonomy. The Act gives significant autonomy to parties in choosing the arbitrator, the procedure to be followed, and the place of arbitration. International commercial arbitration. The Act incorporates provisions for international commercial arbitration, aligning Indian law with international standards. Enforcement of foreign awards. The Act provides for the enforcement of foreign arbitral awards, enhancing India's position as a preferred destination for international trade and investment. Conciliation. The Act recognizes conciliation as an effective method of dispute resolution and provides a framework for its conduct. Limited judicial intervention. The Act aims to minimize judicial interference in arbitration proceedings, promoting the finality of arbitral awards. Provision for appeal. While the Act generally limits judicial intervention, it provides for limited grounds of appeal against arbitral awards. Advantages of arbitration. Arbitration offers several advantages over traditional litigation. Speed and efficiency. Arbitration proceedings are generally faster and less formal than court proceedings, leading to quicker resolution of disputes. Expertise. Arbitrators are often experts in the subject matter of the dispute, leading to more informed decisions. Confidentiality. Arbitration proceedings are private, protecting sensitive business information. Flexibility. Parties have greater control over the arbitration process, including the choice of arbitrator, procedure, and place of arbitration. Cost-effective. Arbitration is often less expensive than litigation due to reduced procedural formalities and delays. Finality. Arbitral awards are generally final and binding, reducing the likelihood of appeals. By providing a robust legal framework for arbitration and conciliation, the Arbitration and Conciliation Act, 1996 has contributed significantly to the development of alternative dispute resolution mechanisms in India. Question 6. What do you understand by arbitration? What are the kinds of arbitration? Discuss the provisions of appointment of arbitrators. Arbitration. Arbitration is a form of alternative dispute resolution, ADR, where parties to a dispute agree to submit their differences to a neutral third party, known as an arbitrator, for a final and binding decision. This decision is called an arbitral award. Unlike court proceedings, arbitration is typically more private, efficient, and less formal. Kinds of arbitration. Ad hoc arbitration. This is the most basic form where parties independently agree on the arbitration procedure without involving any institutional framework. Institutional arbitration. This involves a recognized arbitration institution, such as the Indian Council of Arbitration, ICA, or the International Chamber of Commerce, ICC, which provides administrative support and procedural rules. Expert determination. This is a specialized form where the arbitrator is an expert in the specific field of dispute. Appointment of arbitrators. The Arbitration and Conciliation Act, 1996 outlines the provisions for the appointment of arbitrators. Appointment by agreement. Parties have the freedom to agree on the method of appointing an arbitrator. This can be through a sole arbitrator, a panel of 3 arbitrators, where each party appoints one and the third is mutually agreed upon or appointed by the other two, or any other method agreed upon by the parties. Appointment by court. If parties fail to agree on the appointment of an arbitrator, the Act provides for the appointment by the Chief Justice of the High Court or the Supreme Court, in case of international arbitration. Appointment by arbitration institution. In institutional arbitration, the institution's rules govern the appointment process. Key points to remember. The arbitrator should be independent and impartial. The appointment process should be fair and transparent. The arbitrator should have the necessary expertise to handle the dispute. By carefully considering these factors, parties can ensure the effective appointment of an arbitrator and the smooth conduct of arbitration proceedings. Question 7. What are the grounds on which the appointment of an arbitrator may be challenged and what is its procedure? Grounds for challenging the appointment of an arbitrator. Under the Arbitration and Conciliation Act, 1996, a party can challenge the appointment of an arbitrator on the following grounds. Lack of impartiality or independence. If there are circumstances that raise justifiable doubts about the arbitrator's impartiality or independence, a challenge can be initiated. Lack of qualifications. If the arbitrator does not possess the qualifications agreed upon by the parties or required by the arbitration agreement, the appointment can be challenged. Other grounds. Any other ground that renders the arbitrator incapable of performing the duties or is otherwise disqualified under law can be a basis for a challenge. Procedure for challenging the appointment. The procedure for challenging the appointment of an arbitrator is outlined in sections 12 to 15 of the Arbitration and Conciliation Act, 1996. Notice of challenge. A party wishing to challenge the appointment must serve a written notice to the other party and the arbitrator. Application to court. Within 15 days of serving the notice, the challenging party must file an application with the High Court. Court proceedings. The court will then issue notices to the parties and the arbitrator. The arbitrator can also submit a response. Court decision. The court will decide whether there are sufficient grounds to challenge the appointment. If the challenge is successful, the arbitrator may be removed and a new arbitrator appointed. Important points to remember. Challenges to the appointment of an arbitrator should be raised promptly to avoid delays in the arbitration proceedings. The burden of proof lies with the party challenging the appointment to establish the grounds for the challenge. The court's decision on the challenge is final. By understanding the grounds for challenging an arbitrator and the applicable procedure, parties can protect their interests and ensure the fairness of the arbitration process. Question 8. What is the basis of termination or revocation of arbitration under Arbitration and Conciliation Act, 1996? Termination or revocation of arbitration under Arbitration and Conciliation Act, 1996. The Arbitration and Conciliation Act, 1996 provides for termination or revocation of arbitration proceedings under specific circumstances. Basis for termination or revocation. Completion of arbitration. The most common ground for termination is the issuance of a final award by the Arbitral Tribunal. Once the Arbitral Tribunal has decided all the issues submitted to it, the arbitration proceedings are deemed to be terminated. Impossibility or unnecessary continuation. In exceptional circumstances, if the continuation of the arbitration proceedings becomes impossible or unnecessary, the Arbitral Tribunal may terminate the proceedings. This is a discretionary power vested in the tribunal. Agreement of parties. The parties can mutually agree to terminate the arbitration proceedings at any stage. However, such termination must be clearly expressed in writing. Revocation of submission. A party can revoke the arbitration agreement only if the agreement permits it or if a ground for setting aside the award exists. Key points. The Act emphasizes the finality of arbitral awards, and termination should be based on valid grounds. The power to terminate arbitration primarily lies with the Arbitral Tribunal. Parties should exercise caution when considering termination or revocation as it may have implications for their rights and remedies. It's important to note that the termination of arbitration proceedings does not necessarily affect the enforceability of any interim awards or orders issued by the Arbitral Tribunal. Question 9. What do you understand by arbitration agreement? What are the essential elements of arbitration agreement? Arbitration Agreement. An arbitration agreement is a contract between two or more parties to submit any existing or future disputes to arbitration rather than through the regular court system. It is essentially an agreement to resolve disputes through an impartial third party known as an arbitrator. Essential elements of an arbitration agreement. Under the Arbitration and Conciliation Act, 1996, an arbitration agreement must possess the following essential elements. Agreement to arbitrate. The most fundamental element is a clear expression of the parties' intent to submit their disputes to arbitration. This can be explicit or implied. In writing, the agreement must be in writing. This requirement can be fulfilled in various forms, including a separate agreement, a clause within a contract, or even through an exchange of communications. Signed by the parties. The agreement must be signed by the parties or their authorized representatives. Scope of disputes. The agreement should clearly define the disputes that are subject to arbitration. It can cover all disputes arising from a contract or specific types of disputes. Number of arbitrators. The agreement should specify the number of arbitrators. If not, the default is a single arbitrator. Place of arbitration. The agreement should indicate the place where the arbitration proceedings will take place. By fulfilling these essential elements, parties can ensure the validity and enforceability of their arbitration agreement. Question 10. Explain the provisions of composition of arbitration tribunal and the procedure for impacting authority of arbitrator. Composition of arbitration tribunal. The Arbitration and Conciliation Act, 1996 provides flexibility in the composition of an arbitration tribunal. Number of arbitrators. Sole arbitrator. This is the default option unless the parties agree otherwise. 3 arbitrators. Parties may opt for a tribunal of 3 arbitrators, with each party appointing one and the third being mutually agreed upon or appointed by the other two. Appointment of arbitrators. Party agreement. Parties have the autonomy to agree on the method of appointing arbitrators. Court intervention. If parties fail to agree, the court can appoint an arbitrator. Qualifications of arbitrators. While the Act doesn't prescribe specific qualifications, the arbitrator should be independent, impartial, and competent to handle the dispute. Parties may agree on specific qualifications for the arbitrator. Impugning the authority of an arbitrator. A party can challenge the authority of an arbitrator on the following grounds. Lack of impartiality or independence, if there are justifiable doubts about the arbitrator's impartiality or independence. Lack of qualifications, if the arbitrator lacks the agreed upon or required qualifications. Other grounds, any other ground rendering the arbitrator incapable of performing duties. Procedure to challenge. Notice, the challenging party must serve a written notice to the other party and the arbitrator. Application to court. Within 15 days of serving the notice, the party must file an application with the High Court. Court proceedings. The court will issue notices to parties and the arbitrator, who can submit a response. Court decision. The court decides if there are sufficient grounds to challenge the appointment. Key points to remember. Challenges should be raised promptly. Burden of proof lies with the challenging party. Court's decision is final. By understanding these provisions, parties can ensure a fair and efficient arbitration process. Question 11. Who is arbitrator under the Arbitration and Conflation Act, 1996? Discuss. Arbitrator under the Arbitration and Conciliation Act, 1996. An arbitrator is a neutral third party appointed to resolve a dispute between parties through arbitration. Under the Arbitration and Conciliation Act, 1996, an arbitrator acts as a private judge, empowered to make a final and binding decision on the matter in dispute. Key characteristics of an arbitrator. Impartiality. An arbitrator must be independent and impartial. Any appearance of bias or conflict of interest can undermine the integrity of the arbitration process. Expertise. While not mandatory, an arbitrator with expertise in the subject matter of the dispute is often preferred to ensure a fair and informed decision. Authority. The arbitrator has the power to conduct hearings, gather evidence, make rulings on procedural matters, and ultimately render an award. Confidentiality. Arbitrations are typically confidential, and the arbitrator must maintain the confidentiality of the proceedings. Appointment of arbitrator. The Arbitration and Conciliation Act provides flexibility in the appointment of arbitrators. Sole arbitrator. A single arbitrator can be appointed to resolve the dispute. Panel of arbitrators. A panel of 3 arbitrators can be appointed, with each party appointing one and the third being mutually agreed upon or appointed by the other two. The parties have the autonomy to agree on the method of appointment, but if they fail to do so, the court can intervene and appoint an arbitrator. In essence, an arbitrator is a crucial figure in the arbitration process, acting as a private judge to resolve disputes efficiently and effectively. Question 12. What are the power and duties of arbitration tribunals? Powers and duties of arbitration tribunals. Arbitration tribunals, composed of one or more arbitrators, possess significant powers and responsibilities to conduct fair and efficient proceedings. Powers of arbitration tribunals. Procedural powers. Determine the procedure to be followed in the arbitration. Fix the time and place for hearings. Administer oaths to witnesses. Order the production of documents and evidence. Appoint experts to assist in the proceedings. Grant interim measures, such as injunctions or attachments. Decision-making powers. Interpret the arbitration agreement. Rule on its own jurisdiction. Decide on the merits of the dispute. Make final awards, including determining costs. Duties of arbitration tribunals. Impartiality and independence. Arbitrators must act independently and impartially. Due process. Ensure fair proceedings by providing equal opportunities to both parties. Efficiency. Conduct proceedings efficiently and expeditiously. Confidentiality. Maintain the confidentiality of the arbitration proceedings. Disclosure. Disclose any circumstances that could give rise to doubts about impartiality or independence. Compliance with law. Adhere to applicable laws and the terms of the arbitration agreement. Key points. The arbitration tribunal has broad powers to control the proceedings and reach a final decision. Arbitrators have a duty to act fairly and impartially. The goal is to provide a swift and efficient resolution to the dispute. By understanding the powers and duties of arbitration tribunals, parties can better navigate the arbitration process and ensure a fair outcome. Question 13. What do you mean by misconduct of arbitral tribunal? Misconduct of an arbitral tribunal. Misconduct of an arbitral tribunal refers to any action or omission by the arbitrators that deviates from the standards of fairness, impartiality, and due process expected in arbitration proceedings. It undermines the integrity of the arbitration process and can potentially lead to the setting aside of the award. Common examples of misconduct. Bias or partiality, showing favoritism towards one party, or having a personal interest in the outcome of the case. Procedural impropriety, failing to follow the agreed-upon procedure or the procedure prescribed by the law, which can lead to unfairness. Exceeding authority, making decisions or taking actions outside the scope of the arbitration agreement or the applicable law. Denial of natural justice, failing to provide parties with a fair opportunity to present their case, such as denying the right to be heard or to present evidence. Corruption or fraud, engaging in corrupt practices or fraudulent activities that affect the outcome of the arbitration. It's important to note that mere errors of judgment or differences of opinion between the parties and the tribunal do not necessarily constitute misconduct. The misconduct must be of a serious nature and have a material impact on the fairness of the proceedings. Question 14. What do you understand by arbitration award? What are the essentials of a valid award? Arbitration award. An arbitration award is the final decision rendered by an arbitration tribunal to resolve a dispute submitted to it by the parties. It is the culmination of the arbitration process and is analogous to a court judgment. Essentials of a valid award. For an arbitration award to be valid and enforceable, it must meet certain essential requirements. Finality, the award must definitively settle all claims submitted to the tribunal for determination. It should not leave any unresolved issues. Conformity with arbitration agreement, the award must be within the scope of the arbitration agreement. The tribunal cannot decide matters outside the agreed-upon scope. Compliance with procedural requirements, the award must be made in accordance with the agreed-upon procedure or the procedural rules applicable to the arbitration. Reasoned award, while not mandatory in all cases, a reasoned award is generally preferred to demonstrate the tribunal's reasoning and basis for the decision. Clarity and specificity. The award should be clear and unambiguous, specifying the rights and obligations of the parties. Compliance with applicable law. The award should be consistent with the applicable law and public policy. Formalities. The award must be in writing and signed by the arbitrators. These are the primary elements that contribute to the validity of an arbitration award. An award that meets these criteria is more likely to be upheld by the courts and enforced. Question 15. What are the grounds for setting aside of arbitration award? In which other provision can setting aside awards otherwise Arbitration and Conciliation Act Section 34? Grounds for setting aside an arbitration award. Section 34 of the Arbitration and Conciliation Act, 1996 outlines the grounds on which an arbitral award can be set aside. These include incapacity of a party, if a party was under incapacity or the agreement was void. Lack of proper notice, if a party was not given proper notice of the appointment of the arbitrator or the arbitration proceedings. Composition of the arbitral tribunal or arbitral procedure, if the composition of the tribunal or the arbitral procedure did not comply with the agreement of the parties or the provisions of the Act. Arbitrator exceeding powers, if the award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration. Corruption or fraud, if the award has been procured through corruption or fraud. Public policy, if the award is in conflict with the public policy of India. Other provisions for setting aside awards. While Section 34 is the primary provision for challenging an arbitral award, there are other related provisions. Section 33 provides for correction of clerical, arithmetical, or computational errors in the award. Section 36 deals with the enforcement of foreign awards, and there are specific grounds for challenging the enforcement of such awards under this section. It's important to note that the scope for challenging an arbitral award is limited, and courts generally adopt a cautious approach to interfering with the arbitral process. The emphasis is on finality and the autonomy of the parties. Question 16. What provision about to application for setting aside of award and its limitation under the Arbitration and Conciliation Act, 1996? Explain. Application for setting aside an award and its limitations. Section 34 of the Arbitration and Conciliation Act, 1996 governs the application for setting aside an arbitral award. Application for setting aside an award. A party aggrieved by an arbitral award can apply to the High Court for setting aside the award within a specified time frame. The application must be supported by evidence and grounds as mentioned in Section 34. Limitations on setting aside an award. The Act imposes certain limitations on the power of the court to set aside an award. Time limit. The application to set aside the award must be made within 3 months of the receipt of the award. However, the court may extend this period by up to 30 days for sufficient cause. Scope of judicial review. The court's power to interfere with the arbitral award is limited. It cannot reappreciate the evidence or substitute its own decision for that of the arbitrator. Public policy. The ground of public policy is narrowly construed, and the court cannot interfere merely because it disagrees with the award. Key points. The Act promotes finality of arbitral awards. The court's role is limited to ensuring that the arbitration process was fair and that the award does not violate public policy. The burden of proof lies with the party seeking to set aside the award. In essence, the Act strikes a balance between providing a remedy for aggrieved parties and upholding the principle of finality of arbitral awards. Question 17. How should treatment of arbitrators for parties' conduct of arbitral proceedings? Explain. Treatment of arbitrators by parties in arbitral proceedings. The conduct of parties towards arbitrators is crucial for the smooth and efficient conduct of arbitration proceedings. The parties must treat the arbitrators with respect and dignity. Here are some key points to remember. Respect for arbitrators' authority. Recognizing the arbitrator's role, parties should acknowledge the arbitrator's role as an impartial decision-maker and avoid any actions that undermine their authority. Compliance with arbitrators' directions. Parties should adhere to the procedural directions issued by the arbitrator to ensure the orderly conduct of the proceedings. Avoiding interference. Parties should refrain from interfering with the arbitrator's decision-making process or attempting to influence the outcome improperly. Cooperation and good faith. Active participation. Parties should actively participate in the arbitration process by providing necessary information and evidence. Timely compliance. Parties should comply with procedural deadlines and requirements to avoid unnecessary delays. Open communication. Parties should maintain open and respectful communication with the arbitrator and the opposing party. Avoiding personal attacks. Focus on the merits. Parties should concentrate on the merits of the dispute rather than engaging in personal attacks against the arbitrator or the opposing party. Professional demeanor. Maintaining a professional demeanor throughout the proceedings is essential for creating a conducive environment. Respecting confidentiality. Protecting confidential information. Parties should respect the confidentiality of the arbitration proceedings and avoid disclosing sensitive information without authorization. By adhering to these principles, parties can contribute to a fair and efficient arbitration process and enhance the reputation of arbitration as a preferred dispute resolution method. Question 18. Under what circumstances judicial interference is required under arbitration proceedings? May the court set aside the award on its own motion? Explain. Judicial interference in arbitration proceedings. The Arbitration and Conciliation Act, 1996, while promoting arbitration as a preferred method of dispute resolution, recognizes certain circumstances where judicial intervention is necessary. Circumstances for judicial interference. Appointment of arbitrator. If parties fail to agree on the appointment of an arbitrator, the court can intervene. Interim measures. In exceptional cases, the court may grant interim relief before or during arbitration proceedings. Setting aside the award. Under Section 34 of the Act, the court can set aside an award on specific grounds such as incapacity of a party, lack of proper notice, corruption, or public policy. Enforcement of award. The court plays a role in enforcing domestic and foreign arbitral awards. Injunctions. In rare cases, the court may grant injunctions to protect the arbitration process or its outcome. Court cannot set aside award on its own motion. No, the court cannot set aside an arbitral award on its own motion. The initiation of proceedings to set aside an award rests solely with a party to the arbitration. The court's role is reactive, and it can intervene only when approached by an aggrieved party. Limited scope of judicial intervention. The Act emphasizes the principle of party autonomy and the finality of arbitral awards. Judicial intervention is limited and exceptional. The court's role is primarily to ensure that the arbitration process is conducted fairly and that the award is not contrary to public policy. In essence, the court's function is to provide a safety net for the arbitration process, but it should not unduly interfere with the arbitral tribunal's authority. Question 19. Explain rules about the procedure conduct of arbitral proceedings. Procedure conduct of arbitral proceedings. The Arbitration and Conciliation Act, 1996, provides a flexible framework for the conduct of arbitral proceedings. The primary focus is on party autonomy, allowing parties to agree on the procedures to be followed. However, certain fundamental principles must be adhered to. Key principles. Party autonomy. Parties have the freedom to agree on the procedure to be followed in the arbitration. This includes the place of arbitration, language, and the method of appointing arbitrators. Equality of treatment. The arbitral tribunal must treat all parties equally and give each party a full opportunity to present their case. This is enshrined in Section 18 of the Act. Fairness. The proceedings must be conducted fairly and impartially. The tribunal must ensure that both parties have a fair opportunity to be heard. Efficiency. The arbitration process should be conducted efficiently and without unnecessary delay. Confidentiality. The arbitral proceedings are generally confidential, and the tribunal must maintain the confidentiality of the information shared. Role of the Arbitral Tribunal. The Arbitral Tribunal has a crucial role in conducting the proceedings. Its primary duties include determining the procedure. If the parties have not agreed on a procedure, the tribunal has the power to determine the appropriate procedure. Managing the proceedings. The tribunal controls the proceedings, including setting dates for hearings, admitting evidence, and ensuring the orderly conduct of the proceedings. Making decisions. The tribunal makes decisions on procedural and substantive issues arising during the arbitration. Role of the parties. The parties are responsible for cooperating with the tribunal. Parties must cooperate with the tribunal to ensure the smooth conduct of the proceedings. Presenting evidence, parties must present their evidence and arguments in a clear and concise manner. Observing procedural rules, parties must comply with the procedural rules agreed upon or determined by the tribunal. General conduct. Written submissions, parties typically exchange written submissions before and during the proceedings. Oral hearings may be held at the discretion of the tribunal or at the request of the parties. Evidence, the tribunal has wide discretion in admitting evidence. Interim measures, the tribunal may grant interim measures if necessary. Awards, the final award must be in writing and signed by the arbitrators. It's important to note that while the Act provides a general framework, specific procedures may vary depending on the agreement between the parties, the rules of any arbitral institution involved, and the specific circumstances of the case. Question 14. B. State in reference to place of arbitration for conduct of arbitral proceedings. Place of arbitration for conduct of arbitral proceedings. The Arbitration and Conciliation Act, 1996, grants significant flexibility to parties regarding the place of arbitration. Key provisions. Party autonomy. Parties are free to agree on the place where the arbitration proceedings will be conducted. This is enshrined in Section 21 of the Act. Arbitral Tribunal's determination. If the parties fail to agree on a place of arbitration, the Arbitral Tribunal has the power to determine the place, considering the circumstances of the case and the convenience of the parties. This is provided under Section 22 of the Act. Importance of place of arbitration. The place of arbitration is crucial for several reasons. Applicable law. The law of the place of arbitration often governs the procedural aspects of the arbitration. Enforcement of awards. The place of arbitration can influence the enforcement of the award, especially in international commercial arbitrations. Convenience of parties. The choice of place should consider the convenience of the parties, witnesses, and arbitrators. Additional considerations. Institutional rules. If the arbitration is conducted under the rules of an arbitral institution, the institution's rules may also specify the place of arbitration. Multiple sittings. The tribunal may hold hearings or consultations at different locations if necessary. In essence, the place of arbitration is a critical aspect of the arbitration process, and parties should carefully consider this factor when drafting the arbitration agreement. Question 20. How to commencement of arbitral proceedings under the Arbitration and Conciliation Act, 1996. Explain. Commencement of arbitral proceedings. The Arbitration and Conciliation Act, 1996, outlines the process for commencing arbitral proceedings. The key provision governing this is Section 21 of the Act. Commencement of arbitral proceedings. Request for arbitration. The arbitral proceedings commence when a party, usually the claimant, sends a request to the other party, respondent, to refer the dispute to arbitration. This request should clearly specify the dispute and the intention to invoke the arbitration clause. Receipt of request. The arbitral proceedings are deemed to have commenced on the date the respondent receives the request for arbitration, unless the parties have agreed otherwise. Essential elements of a request. Clear indication of dispute. The request must clearly outline the nature and scope of the dispute. Reference to arbitration clause. The request should explicitly refer to the arbitration clause in the contract. Invitation to arbitration. The request should invite the respondent to participate in the arbitration proceedings. Importance of commencement. The commencement of arbitral proceedings is crucial for determining several aspects, including time limit for challenging arbitral award. The time limit for challenging an award starts from the date of commencement of arbitral proceedings. Applicable law. The law governing the arbitration process often depends on the date of commencement. Conclusion. The commencement of arbitral proceedings marks the beginning of the dispute resolution process outside the court system. It is essential to ensure that the request for arbitration is clear, specific, and timely to initiate the proceedings effectively. Question 21. Who can make statements of claim and defense in conduct of arbitral proceedings? Explain. Who can make statements of claim and defense in arbitral proceedings? Under the Arbitration and Conciliation Act, 1996, the parties to the arbitration agreement are the ones who can make statements of claim and defense. Statement of claim. The party initiating the arbitration, typically referred to as the claimant, is responsible for drafting and submitting a statement of claim. This document outlines the facts supporting the claim, the points at issue, and the relief or remedy sought. Statement of defense. The other party to the arbitration, usually called the respondent, prepares and submits a statement of defense. This document presents the respondent's version of events, the defenses to the claim, and any counterclaims they may have. It's essential to note that the parties have the flexibility to agree on the specific content and format of these statements, as well as the timeline for their submission. The Arbitral Tribunal may also provide guidelines or rules for the preparation of these documents to ensure fairness and efficiency in the proceedings. Question 22. When Arbitral Tribunal or a party with the permission of the Arbitral Tribunal Court's assistance in taking evidence in conduct of arbitral proceedings? Explain. Court's assistance in taking evidence in arbitral proceedings. Section 27 of the Arbitration and Conciliation Act, 1996, provides a mechanism for the Arbitral Tribunal or a party, with the Tribunal's approval, to seek the assistance of the court in taking evidence. Circumstances for seeking court assistance. Difficulty in compelling attendance. When a witness is reluctant or refuses to appear before the Arbitral Tribunal, the court's coercive powers can be invoked to compel attendance. Production of documents. If a party is unwilling to produce documents, the court can order the production of specific documents. Examination of witnesses. The court can be requested to conduct the examination of witnesses, especially in cases where the tribunal deems it necessary or convenient. Other forms of evidence. The court's assistance can be sought for obtaining evidence in forms other than witness testimony, such as expert reports or documents. Procedure for seeking court assistance. Application to the court. The Arbitral Tribunal or the party, with the tribunal's approval, must file an application with the court seeking specific assistance. Court order. Upon receiving the application, the court may issue orders for the issuance of summons, commissions for the examination of witnesses, or other necessary processes. Compliance. Persons failing to comply with the court's orders are subject to the same penalties as in ordinary court proceedings. Limitations on court's assistance. While Section 27 provides for court assistance, it is essential to note that the court's role is supplementary to the arbitral process. The tribunal retains the primary responsibility for conducting the proceedings and evaluating the evidence. Key points. The court's involvement is limited to assisting the arbitral tribunal in gathering evidence. The tribunal retains control over the proceedings and the assessment of evidence. The purpose of seeking court assistance is to overcome difficulties in obtaining evidence and ensure the fair and efficient conduct of the arbitration. By effectively utilizing Section 27, parties and tribunals can overcome challenges in evidence gathering and strengthen the arbitration process. Question 23. What are the provisions of appeal in Arbitration and Conciliation Act, 1996? Provisions of appeal in the Arbitration and Conciliation Act, 1996. The Arbitration and Conciliation Act, 1996, generally promotes the finality of arbitral awards and limits the scope of judicial intervention. However, it does provide for certain appeals in specific circumstances. Appeals against court orders. Section 37 of the Act allows for appeals against certain court orders. Orders granting or refusing interim measures under Section 9. This section deals with interim measures like injunctions or attachments granted by the court. Orders setting aside or refusing to set aside an arbitral award under Section 34. This section pertains to appeals against court decisions on challenges to the arbitral award. Appeals against arbitral tribunal orders. While the general principle is to avoid appeals against arbitral decisions to maintain the finality of the award, Section 37(2) provides for limited appeals against certain orders of the arbitral tribunal. Orders accepting or rejecting a plea under Section 16. This section deals with the arbitral tribunal's jurisdiction. Orders granting or refusing interim measures under Section 17. This section pertains to interim measures granted or refused by the arbitral tribunal. Limitations on appeals. No second appeal. The Act prohibits second appeals, meaning that the decision of the appellate court is final. Supreme Court appeal. The Act does not affect the right to appeal to the Supreme Court under other laws. Key points. The scope of appeals is limited to specific court orders and certain arbitral tribunal orders. The Act emphasizes the finality of arbitral awards. Appeals are subject to the limitations imposed by the Act. It's important to note that the availability of appeals may vary depending on the specific circumstances of the case and the applicable laws. Question 24 What provision in reference to revision under the Arbitration and Conciliation Act, 1996? Explain. Revision under the Arbitration and Conciliation Act, 1996, a non-existent provision. There is no provision for revision under the Arbitration and Conciliation Act, 1996. The Act primarily focuses on promoting arbitration as an efficient and expeditious method of dispute resolution. To maintain the finality of arbitral awards and to avoid prolonged litigation, the Act limits judicial intervention. Available remedies. While there is no specific provision for revision, parties can seek redress through the following avenues. Appeal. As discussed earlier, the Act provides for limited appeals against certain court orders and arbitral tribunal decisions. Setting aside award. If the award is found to be contrary to public policy or suffers from other legal infirmities, it can be set aside under Section 34 of the Act. Enforcement or non-enforcement. Parties can seek enforcement or non-enforcement of the award through appropriate legal proceedings. In conclusion, the concept of revision is not applicable to arbitration proceedings under the Arbitration and Conciliation Act, 1996. The Act provides alternative mechanisms for parties to challenge or enforce arbitral awards. Question 25 What are the provisions for appointment of receiver in Arbitration and Conciliation Act, 1996? Appointment of receiver under the Arbitration and Conciliation Act, 1996. The Arbitration and Conciliation Act, 1996, does not specifically provide for the appointment of a receiver. However, the Act does grant broad powers to the Arbitral Tribunal to order interim measures, which can be interpreted to include the appointment of a receiver in certain circumstances. Interim measures and potential appointment of receiver. Section 17 of the Act empowers the Arbitral Tribunal to order interim measures, including preservation of the property that is the subject matter of the dispute, taking of interim measures for securing the evidence, preventing any action which would cause harm to the arbitral process, granting interim relief of a nature similar to that which may be granted by a court under its inherent jurisdiction. While not explicitly mentioned, the power to preserve the property could be interpreted to include the appointment of a receiver if the tribunal deems it necessary to protect the subject matter of the dispute. Court's role. In cases where the arbitral tribunal finds it difficult to appoint a receiver or where the matter is complex, it may seek the assistance of the court under Section 27 of the Act. The court can then appoint a receiver under its inherent powers. Key points. The power to appoint a receiver is not expressly provided in the Act but can be inferred from the broader powers of the arbitral tribunal. The appointment of a receiver is an exceptional measure and should be resorted to only when necessary to protect the subject matter of the dispute. The court's role in appointing a receiver is supplementary to the arbitral tribunal's powers. It is essential to note that the appointment of a receiver is a complex issue, and the specific circumstances of each case will determine whether it is appropriate and how it should be approached. Question 26 Who can make reference to arbitration and how? Who can make a reference to arbitration and how? Only parties to an arbitration agreement can initiate arbitration proceedings. This means that a reference to arbitration can only be made by a party who is bound by the arbitration agreement. How to make a reference to arbitration? The process typically involves the following steps. Identification of the arbitration clause. The party initiating arbitration must identify the arbitration clause within the contract. This clause outlines the agreement to resolve disputes through arbitration. Drafting a notice. The party should draft a clear and concise notice to the other party, indicating the intention to initiate arbitration. This notice should include a clear statement of the dispute, a reference to the arbitration clause, a proposal for appointing arbitrators or referring to the agreed-upon appointment procedure, any other relevant details. Service of notice. The notice should be served on the other party in accordance with the agreed-upon method of service or as per the applicable law. It's important to note that the arbitration agreement must be valid and enforceable for the reference to arbitration to be effective. Once the reference to arbitration has been made, the arbitral proceedings can commence as per the terms of the arbitration agreement or the applicable arbitration rules. Question 27 How the arbitration proceeding is effected when a party to the proceeding is declared as insolvent? Impact of insolvency on arbitration proceedings. The insolvency of a party to an arbitration proceeding significantly impacts the course of the arbitration. The interplay between arbitration and insolvency laws creates complex scenarios. Key considerations. Moratorium under Insolvency and Bankruptcy Code, IBC. The commencement of insolvency proceedings imposes a moratorium on the institution of any suit or proceeding against the corporate debtor. This moratorium can impact ongoing arbitration proceedings. However, the exact impact depends on the stage of the arbitration. Role of the Insolvency Resolution Professional, IRP. The IRP assumes control of the corporate debtor's assets and affairs. The IRP may choose to continue or terminate the arbitration proceedings based on the best interests of the creditors. The IRP can also apply to the National Company Law Tribunal, NCLT, for directions regarding the arbitration. Impact on arbitration proceedings. Pre-award stage, the arbitration may be stayed or suspended during the moratorium period. The IRP may decide to continue or terminate the arbitration. Post-award stage, the enforcement of an arbitral award against the insolvent party may be subject to the moratorium and the claims resolution process under the IBC. Interaction between arbitration and insolvency laws. There is a complex interplay between the Arbitration and Conciliation Act, 1996 and the Insolvency and Bankruptcy Code, 2016. Courts and tribunals have been grappling with issues related to the coexistence of these two regimes. Challenges and uncertainties. The exact impact of insolvency on arbitration proceedings is often uncertain due to the evolving nature of insolvency law and limited jurisprudence on the subject. Balancing the interests of creditors and other stakeholders while ensuring the efficient resolution of disputes is a complex task. In conclusion, the insolvency of a party significantly affects the arbitration proceedings, and careful consideration of the applicable laws and the specific circumstances of the case is essential.